Good afternoon, everybody, and a warm welcome to everyone on the call this afternoon. Thank you for joining us for this webinar to talk all things AI and IP. My name is Janine Thomas. I head up the firm's commercial IP practice area, and our team focuses primarily on all commercial related transactions where there is an IP implication. I have on the call with me my colleague, Dr. Bernard Diepenaar, who is a patent attorney. He's also part of the commercial IP team, and together we'll be presenting on several topics this afternoon. We've obviously taken a very keen interest in AI because AI is really reshaping how we own, how we create, and how we develop IP. And IP is really at the cornerstone of protecting, concepts of the mind and creations of the mind. So, there are various forms of IP that, are relevant in any particular circumstance, but today we're going to focus on patents and copyright primarily because those are the areas that are most impacted by AI. And I'm just going to ask Bernard to please share our presentation so that I can just run you through the structure of today's webinar. So Bernard will start off by just chatting about an introduction to AI generation. He'll chat to us about patent protection of inventions using AI. He'll then also look at digital replicas and deepfakes as they pertain to patents. I will touch on very briefly personality rights in the context of digital replicas and deepfakes. I will then also touch on copyright and AI. And in this regard, we'll also look at some of the developments outside of Africa and how those developments impact South Africa, if at all, from a copyright perspective. We will then also look at the legislative landscape in Africa and what some of the other African countries are doing from an AI perspective. And then we'll close off with some concluding remarks and key takeouts, which we hope will be useful for you, in supporting your business in this AI journey that they move on. So without further ado, I'm going to hand over to my colleague Bernard to take us through the patent part of our webinar. Bernard, over to you.
Perfect. Thank you so much, Janine, and good afternoon, everyone. Thank you for joining us today, and welcome to what is a very interesting topic. So just a few brief comments on what AI generation is and how it works. So generative AI refers to artificial intelligence systems that are capable of creating new content such as text, images, music, even video, computer games, and code. And this is then based on patterns that are learned from existing data. Now, this is typically done in 3 steps or 3 procedures. The first one is training. And this is where the AI is trained on a large subset of data. And these large data set, it learns the patterns, the structures, and the features of that data. Then you've got models. These are typically neural networks or especially deep learning models like generative adversarial networks, and then also the typical large language models that we've heard about a lot. Finally, then there's the step of generation, and this is once the AI has been trained, it is capable of producing new content by predicting what comes next in the sequence by combining the learned features in novel ways. So just moving then on to patents, and as Janine said, this is a big portion of our topic today, and I think it's very important. So patents are what we like to call a quid pro quo, or this give and take relationship. And what you give is you disclose the invention in full in that patent application. So it really needs to be extensive, and someone reading that patent document should be enabled or empowered to almost reverse engineer the whole invention simply by looking at that patent document. And then in turn for that, or what you kind of take from the people of that jurisdiction where the patent is filed, is you take rights away. So it's called negative rights. So once you have a patent, you can enforce that patent document or the rights under that patent, and you can stop other parties from making, using, offering to dispose of or even importing the underlying invention. So that's kind of that give and take relationship. And it's between you as the patent holder and the government of that jurisdiction. And I'm focusing on calling it jurisdictions because patents are jurisdictional. You need to file patents in all of the countries where you want to protect your underlying technology. Okay, that patent document will also be published. And I think that there might be some confusion there because some of my clients want to either have something as a trade secret or as a patent. You can't have both. It can be a bit of a blend, but that's going to separate your rights. So you either need to decide, are you going to have a patent and protect your invention for a period, which is typically 20 years. It's only extendable in the United States, I believe, and that's very special circumstances, maybe medicinal reasons. It took quite a while to get FDA approval. And yeah, so then you get those exclusive rights when a patent is filed and it is registered and granted. Now, I give these two examples because I know a lot of us on the call, we are aware that BlackBerry used to sell phones, mobile phones. Usually everyone had a BlackBerry and it was quite the in thing. But you would have all noticed that BlackBerry no longer making phones that I'm aware of, and they're actually managing a patent portfolio of about 42,000 patents. They're not selling a lot of hardware, if any. So they are licensing out the underlying technology in that massive patent portfolio. It deals a lot with telecommunications and data science and security systems. And recently, actually, they sold a portion of their patent portfolio. I think it's about 30% of their portfolio for a transaction to the value of $1 billion US. And they are also routinely licensing portions of their patent portfolio to various third parties for multi-million US dollar deals. So it's very interesting to see how BlackBerry has completely pivoted to license and sell intellectual property. Okay, and another example is Nokia. Between 2021 and 2024, they had a lot of these patents that are called standard essential patents. Basically, these patents set the standard of certain technologies. And in this instance, it dealt with 4G and 5G. And they licensed these technologies to various parties, but they were involved in a litigious case with Oppo that dealt, or it spanned over 4 or 5 years. Eventually, the parties settled, and Oppo agreed to pay license fees for those years. And it is estimated that they are going to be licensing their technology for 1.5 billion euros, apologies, every year. So it's quite interesting to see these companies and how they license out their technologies. Now, our Patents Act is very specific on what is patentable. And this is quite harmonized across the world. So our Patent Act actually says that you can't patent business methods and software, but it says as such. All this talk would have been very short. So basically, business methods and software, they form part of almost every invention today, but it can't be the only aspect of that invention that you are trying to patent. So every single device almost these days incorporates some form of software, but there should be several components working together in that system where the software is just a small part of it. And that's typically actually because the software or the code is protected by copyright. So you basically claim the underlying technology and the overall system when you incorporate software or business methods into that technology. And it is very important that patents are for new technology. Now, our act, and this is also harmonized across the world, you can only patent something and protect it with that patent application if it basically adheres to these 3 requirements. So the first one, and if there's anything to remember today, I feel is a very important takeaway because I have clients coming to me with your friend at the braai, or you very excited about your project and you disclose it on LinkedIn, then that might be considered as a public disclosure, and your invention might no longer be patentable. And it's also not just limited to South Africa. So if you go and disclose your invention in the United States and you come back and think that you still can file a patent in South Africa, also very likely that you can no longer patent it. So that's very important. Before you disclose the invention, make sure that there's a possibility of protecting it with a patent before it is disclosed. And this would also include conferences or road shows. Okay, and the second pillar is it must not be obvious. This is typically when your invention, there's a lot of people skilled in the art that would be working in that field of technology. And if it would be obvious to them to make a small change to existing technology to arrive at your invention, then it would be obvious. And I also always like to use the example, someone has created a valve and it was very commercially successful, and someone comes along and they develop a manufacturing process to simply change the constitution of that valve from iron to aluminium. Now, while it might be lighter and the strength might be different, I think we can all agree that it would typically be very obvious to just change the material. So that's an instance where something would be obvious to someone skilled in the art. But mind you, if the manufacturing process is very complicated, it's not easy to produce that valve being manufactured from aluminium, that might be something that is patentable. And the last requirement is that it should be capable of being used in trade, industry, or agriculture, or it must be commercially useful. And this pillar is typically always adhered to. I've never seen an instance where it was not been. So typically it's only the challenges are novelty and it must be inventive. Now, coming back to the intersectionality of patents and artificial intelligence, I thought to give you some broad examples of when artificial intelligence can be incorporated into everyday inventions and where they might be patentable, just by way of some broad categories, and I'll delve into some more specific examples so you can know when something might be patentable. So typically, if there is a unique algorithm or model, maybe you've got decades of data that can be ingested by this algorithm or model, and then it gives unique product insights or product suggestions, or even client-specific or user-specific suggestions, so that you can use that data in a new and unique way to target clients very specifically. So that underlying model or algorithm might be patentable. Then you've got AI-driven devices. I have a few nice examples later on in my slides, but a lot of devices today are using some form of artificial intelligence to make decisions in real time. That device might change the way it operates in response to signals where it receives data from sensors located on that device. But then it's driven by AI and the underlying technology. Then also AI-based data processing methods. This will typically be when there's an underlying method of processing the data much faster or cheaper or more efficiently. That's also something that might be patentable. AI-enabled user interfaces, a lot of chatbots and underlying technologies where you've got these avatars and maybe just a simple chatbot to make automated decisions on a user interface. That is also something that has been patentable. Or a unique way like Amazon patented is its one-click shop method, where you just have to click once and that purchase is done. So there's a very interesting algorithm underneath that, and that was also something that has been patented and protected for quite some time. Then AI applications in specific fields. A very interesting example of a documentary I watched was where a radiologist was working with an AI company to see if they can predict sooner or earlier when someone develops or is a high candidate to develop breast cancer. And this radiologist provided decades of x-rays where the patients eventually did develop breast cancer and fed it into this algorithm. And it was actually capable of predicting even 10 years earlier than this radiologist with 30 years of experience is capable of predicting when someone will have breast cancer or a high propensity to have breast cancer in the future. And that's just an interesting medical device or algorithm example of how AI can be used in these unique inventions to really, really benefit us. Also, when I used to be involved in my studies, We dealt a lot with pharmaceuticals and biofolding, and how you try and identify these zones in these large macrostructures to determine how you can synthesize more efficient pharmaceutical compounds. And back in those days, it took sometimes months to actually test these zones to determine if you can make small changes to pharmaceuticals and have a more potent drug. And several problems were left unanswered and unsolved. And with the advent of AI and these very powerful clusters of LLMs solving these problems, a lot of these problems are now being solved in mere hours. So it's just interesting to see how powerful these things have become today. And then finally, also AI-enhanced security systems. Here you can have some kind of software built into your system to stop someone from making fraudulent transactions, or maybe catching someone before they engage a third party that wants to commit fraudulent acts, or even in a home where you've got sensors that detect when a person is trying to enter the property, and then it can automatically let the alarm go off. So those are just some examples there. And this graph I just included to show how many patent applications are being filed that incorporate artificial intelligence to some degree. So just to see, a few hundred patent applications were filed the first few years here, and you see that it's been exponentially gone up. And I think it's obviously become a big buzzword today, but as I will show with my last few examples, they're really finding very interesting applications in everyday household devices. So artificial intelligence, really, it's becoming ubiquitous. And there's a little bit of a drop off the last few years, but that's just basically because the data from patent applications, there's a bit of a delay in some patent offices. So I think where we had the peak of 25,000 patent families, mind you, so each family might have 10 or 20 patents in them as well in the different countries. I believe that graph will only continue to go up, as is evident from the trend line there as well. Okay, and this table, or this bar graph, just shows you what companies are currently filing these patent applications, the top filing companies. And you will note that there are several very typical names in our households. They produce a lot of the products that we found in our houses and that we keep on our person, and a lot of foreign universities as well. And that's because a lot of these countries where these universities are based, some of the countries have incentives whereby the applicants can maybe get a rebate, or it improves their scientific standing if they file a lot of patents. So there's really a big push in some of these countries to file patents in this space. And a lot of the other countries, they really incorporate artificial intelligence into their devices in a very unique way to get that edge over their competitors. So it's really interesting. There's also a few banks, and a lot of those technologies are more in the crypto space, and maybe some unique ways to stop fraudulent activities from taking place. Right, I thought to include a few concrete examples of devices that are being used in our everyday homes. So in this instance, Roomba, while it is a bit difficult to get the Roomba into South Africa, it can be ordered over Amazon, but I'm starting to see a lot of people having these mobile robots in their houses. And I was actually in someone's house the other day that completely convinced me to get one, because this little device firstly starts, it interacts with this app on your phone, and then it's got this underlying artificial intelligence model whereby it uses sensors located on the robot. And in the first instance, it completely maps out your whole house. And then some of them can even climb stairs, and then it creates on the app the different rooms, and it maps it perfectly. And it also determines how often to clean the rooms. It continuously gets trained and recognizes patterns. Very interesting, and it's completely autonomous. You click a button, it runs it twice a week, and then it goes back to its little docking station. I just found it extremely interesting. I'm actually in the process of purchasing one. Then a lot of washing machines. When I was initially doing some studies to find some household items, I found such interesting examples, and I thought, wow, how could AI be incorporated into washing machines? But it's actually quite complicated. The underlying artificial intelligence model built into a lot of these machines. It interacts with sensors located within the washing machine, and then it actually detects with the different washing loads and the different cycles how to wash the clothing more efficiently, using less electricity, but also applying less stress to the clothing. And it learns these patterns with your specific clothing bundles as well. And then it's been reported that it actually provides 18% more fabric protection. I'm guessing it just means that it extends the lifetime of your clothing over the years of washing them. So very interesting. And this is in a lot of the devices being sold in South Africa today already. Another example from LG, I think this was launched earlier this year in 2025 March. And these AC systems, they are actually capable of detecting, together with the mobile application, when people enter the room and how long they are there and the different regions and zones of your room. And it then controls its vents and the flow of air, and it actually monitors and regulates the temperature perfectly by really using that data and training that model over time. So it actually uses less electricity, but it keeps the temperature exactly where you want it to be. So this was also launched, and these products are being sold in South Africa. And then I also found it interesting the other day walking through a lot of the malls, you're starting to see more and more of these electronic charging ports for the EV vehicles or electric vehicles. And I know a lot of them will eventually find their way to South Africa, and I've already seen a lot of them on the roads. But Tesla, for example, and we've all been exposed to this, they've been training their self-driving system over years now, and they've really revolutionized this. And how it works is it uses a lot of cameras on the vehicle, and then it's capable of being trained over time to determine when something is a vehicle or an object. And you might have seen some videos where in a split second, these vehicles need to decide whether it's going to hit a person or an object. And it's been trained to prioritize human life. So in that split second, it would rather crash than hurt a human. So this is going to be used in a lot of self-driving vehicles in the future. Now, sometimes it's difficult, and I might have overload you with information today. So I just wanted to highlight some key words to kind of identify when an invention or project you're working on, when something might be patentable. And because sometimes it really is difficult. And I think everyone thinks that you need to develop a new combustion engine for something to be patentable, but that's actually not true. A lot of the patented inventions and a lot of the very important inventions out there are actually incremental improvements to existing technologies. But once it gets commercialized, you realize why that incremental change was actually such an important and patentable concept. Okay, so if you're working on some type of technology, typically when that solution it offers, when it does something faster, cheaper, and or more efficient, only one of these, it might be something that is patentable. So either faster, either cheaper, or more efficient. Then if it uses that algorithm or data processing method in a unique way, you'll recall I mentioned it uses the decades of data or maybe even a few months of data, but it ingests it in a very unique way because the underlying algorithm processes that data and it gives this very unique output or outset. And this is now going back to the washing machine and the AC. You would have thought that such simple household items are using these algorithms in a very unique way. Okay. Also, if it improves computer performance. So a lot of inventions these days have a very unique algorithm to actually process data more efficiently and do it faster or cheaper. These days, if you can save on some resources and just do something a bit faster, then it's something that's really patentable. And a lot of the courts overseas have decided this quite definitively. And then all of these very specific practical examples, the self-driving vehicles, the washing machine, the medical diagnosis of those x-rays for cancer, all these specific examples when they incorporate artificial intelligence models in some way. Okay. Now, this was very interesting, and you might have heard about it, but South Africa was quite famous across the world, at least amongst the patent attorneys, when we became the first country to allow a patent to proceed to registration or to grant, where the inventor was actually an algorithm. And mind you, this was also before the ChatGPTs entered the mainstream news, a few years before that. And the software developer of this AI system, Darbus, I think his name is Stephen Thaler, he developed this AI system to go and look for a problem on the internet, to scour the internet, find that problem, and solve it. And it ended up finding a problem, solving it, and he filed a patent for this, but he listed the inventor as this machine. Now, South Africa doesn't have an explicit exclusion of this, so our patent proceeded to grant, and a lot of other countries initially allowed this patent to proceed to grant, but then it was subsequently overturned. But a lot of the judges in those countries actually acknowledged that a lot of these acts are from the 1990s, some of them even the 1950s and 60s. And the judges said that things are moving so quickly that a lot of these acts need to basically catch up. And I know, for example, South Africa and several countries across the world struggling a bit to grapple with these quick changes, and a lot of the acts are now being completely overhauled. Not overhauled, but probably improved to address these deficiencies and challenges that need to be addressed. Now, moving on to digital replicas and deepfakes, and every time I read up about this, there's such interesting developments, and quite an interesting intersection with intellectual property as well. So just briefly, what are digital replicas? So they are highly realistic digital versions of people, objects, or even environments. These replicas are created using very interesting and complicated underlying technologies, artificial intelligence models, and the like. And they use very advanced computer graphics and hardware. And they are then capable of generating, for example, a digital replica of that person that can mimic that person's appearance, their voice, their mannerisms, even the cadence of their voice. And they are often used in films, video games, virtual reality, or creating avatars. And it's very interesting that I also read the other day that someone was saying that the digital replicas being used in a lot of computer games, I think they specifically mentioned Grand Theft Auto, GTA, they said that digital replicas of people in that computer game was better than the CGI graphics in the new Superman movie. And that's just such an interesting example of how these technologies that can be accessed by every single person on their single computer are now rivaling, these multi-studio movies. And then deepfakes are the other example. And this is when media or material or video can be manipulated to mislead the viewers. Okay, so I hope the sound works, but I just have a quick video here to show you. This was a very recent example of a deep fake being reported. It didn't gather enough news, in my opinion, or enough headlines, but
news.
Let's play it
According
quickly.
to insiders, the South African government tried to delay the launch of a powerful financial platform. Officials wanted time to test its safety, but now it is open to the public, and results are shocking banks and corporations.
I was one of the first to see this project in action. To be honest, I was skeptical, but I decided to try it myself. With a simple deposit of 4,400 Rand, the system generated over 40,000 Rand in the first 2 weeks. By the end of the month, I had withdrawn more than 80,000 Rand directly to my bank account. This platform, called Quantum AI, uses artificial intelligence to analyze global markets in real time. It only makes trades when profit potential...
Okay, I'm going to stop it there. But this was such an interesting thing where this ad was being played on the YouTube, the Facebook, all social medias, and a lot of people really thought that this was Trevor Manuel and the news anchor there, because it's quite believable. And I've gone through several years of these deep fakes, and I've actually reported a lot of them being played as ads over the years, and the difference in the quality and the mannerisms, it's just becoming so difficult to identify when these things are fake these days, that a lot of people are really falling for this. I think in this instance, I hope it's easy to identify that if an investment like that, if it's too good to be true, it really is. But it's a bit concerning for me that it's just becoming more and more difficult, because the voice, the cadence, everything is just becoming very realistic. Then I've just got two more examples of deepfakes, just to give you examples of what you need to be on the lookout for, because these artificial intelligence models underlying these deepfakes are really improving on almost weekly basis. So in this instance, Arab, the firm, someone contacted or set up a meeting with one of the employees, and when they joined the call, it was actually a group of the executives on the call, and they then gave instructions to this employee to make several transactions. And this employee really was fooled by this deep fake call of several executives communicating they wished to him to make these transactions. And actually 15 transactions were made before this fraudulent activity was identified. I think it's a total of $25.6 million was transferred. And that's just interesting. And this was a few years ago. So I believe that the deepfake will even be more powerful today. And then there's another example where the former Kenyan Prime Minister, deepfake was made of them to promote some crypto Kenya token. And then the value was, they call it the pump and dump. Everyone invested into this because they believed it was the prime minister promoting it. And then all of those people lost their money, because these deepfakes really are becoming more and more believable. And then just some quick examples of some of the digital replica and deepfake technologies are, I don't want to say all of them are just being used for these scams. Some of them are actually very interesting and finding interesting applications in a lot of commercial products. So Apple has filed several patents for their animojis or their face generation technologies. And then what this does is it actually takes several images or videos of you as the user, and then it generates these avatars that can mimic some of your expressions and the way that you wink and all these interesting things. And it makes it quite believable that it's related to that person. And they actually really aggressively protect this technology. Various other companies have tried to reverse engineer it. And because they have these patents for all of this technology, they've protected the underlying algorithm that is capable of converting your images and video to these avatars. And in some instances, they're licensing out these technologies. Also, a very interesting example here is this technology. They've developed an underlying algorithm that is capable of someone working at a call center. Let's call it a primary agent. They are contacting a possible client and they are starting the call. And then this is a smooth transition where after this agent has been speaking to the possible client for a while, they can actually hand over the process to the secondary agent, which is a deep fake agent that has been trained to speak in exactly the same way as the primary agent, the actual person. And then it can continue the call, sometimes for up to 40 minutes, answering the specific questions and relaying the information to the client. And I've seen, since even finding this patent, that there are some unicorn companies being VC funded where they are generating deep fake agents that the underlying algorithm can be licensed to companies. It can be trained with their material, and you create a digital agent that can seemingly completely carry out a phone call to a potential client. Yeah, I know sometimes we get a lot of robocalls. It's going to be interesting to see how this might be going forward if this technology is going to be implemented. Okay, so moving on then to digital replicas and deepfakes, personality rights, I'll be handing over to Janine.
Thank you so much, Bernard. Lots of interesting stuff happening there in the patent space. So I thought that while we are on the topic of digital replicas and deepfakes, that we touch very briefly on personality rights. Now, personality rights are not intellectual property rights as such. There is an overlap, but it does become quite relevant in the context of digital replicas and deepfakes. So Personality rights basically protect a person's right to their identity and their dignity. And these are protected in terms of the common law and the Constitution. And one of the things that your personality rights also entitle you to is to use aspects of your identity, such as your name, your likeness, and your image, for commercial purposes. So you can essentially use it as a form of income. Now, in South Africa, there's a wealth of, case law around personality rights. It's quite well established in South Africa, but there isn't any case law as yet around personality rights and digital replicas or deepfakes. There was an example that arose in the USA in relation to an app called Reface, and the image on the screen is essentially an indication of how Reface works, but it allows the users to essentially do a face swap where they can take the face of a celebrity, for example, and then they can create movie clips and movie images, etc. And some of the celebrities in the US have actually taken objection to this on the basis that the use of their name, likeness, and image is actually an exploitation of their personality rights, because it's for paid subscription, and essentially it's reducing their own ability to commercialize their image, name, and likeness. So we're likely to see more of this coming about. And I think personality rights also become quite relevant in the context of influencer marketing, which is very prevalent in this day and age, because that is exactly what influencers do, is they use the image and likeness for commercial purposes. So it is something to look out for, even though it might not be a clear intellectual property issue. There are personality rights that also arise in the context of digital replicas and deepfakes. So many jurisdictions are grappling with how to deal with digital replicas and deepfakes. And you would have seen from Bernard's discussion that, some of these digital replicas and deepfakes can actually be used for very malicious purposes. And this is a massive concern. And Denmark has actually made suggestions for amendments to their copyright legislation, in terms of which they will allow their citizens to obtain copyright in an image of their face. Now, that's quite unusual, because that's not normally what copyright protects. But the idea is that citizens will then be granted specific remedies. For example, they'd be able to demand that the online platform removes the content if it's shared without consent. And then there's also some suggestions around what may or may not still be acceptable. For example, parodies and satire would still be considered to be acceptable. Now, the image on the right is obviously an image of the late Pope dressed in, quite funky gear. And I guess the question is, when is it satire? This might be funny to some people, but to another religious group of people, it actually just might not be funny. So it then, becomes a question of balancing the intellectual property rights on the one hand versus, your right to freedom of expression on the other hand. And it would be interesting to see how they actually implement this law going forward. But it is something that is being proposed as a means to dealing with digital replicas and deepfakes. So turning now to copyright. So copyright at a high level protects works of artistic or literary merit. Most jurisdictions, which are Berne Convention countries, set out specific types of works that can be protected. These include literary, musical, artistic works, but they also include computer programs. For most jurisdictions, the rights vest automatically, and there's no need for registration. So provided you use the level of skill, labor, and effort in the creation of the work, the copyright comes into existence automatically. You can register a cinematograph film as a form of copyright in South Africa, and the US also does permit registration of copyright works. Now, when we talk or when we look at the aspect of copyright and AI, there's three essential buckets of issues that arise. And the first is around whether or not there is copyright that actually subsists in the outputs that are generated by AI, and if so, who owns them? And the reason why this becomes a point of discussion is because copyright law is very centered around the author of the work, right? And the author of the work is generally defined as a person, which is a natural or juristic person. And the South African Copyright Act then goes on to define who the particular author of a work is. Now, in the context of a computer program, the author is the person who exercises control over the making of the work. And even in cases where there's no direct or obvious human involvement, the courts have said that in the case of what we know as a computer-generated work, it's the person by whom the necessary arrangements for the creation of the work were taken. So there's a huge focus on the author being a person in the context of copyright law. Similar jurisdictions follow the same logic. Even in the US, the images on the screen relate to a photographer, Mr. David Slater, who was a wildlife photographer. He left his camera in the wildlife, and our dear friend on the right there took a wonderful picture of himself on his own. And when the photographer wanted to register copyright in the US for the photograph, the US Copyright Office rejected this on the basis that human authorship is a bedrock requirement of copyright. So in other words, if there was no human involvement in the creation of the work was not eligible for copyright. More recently, China has taken a much more liberal approach in the context of AI, and they have said that AI images are actually copyrightable, and that the level of creativity that one would consider would be satisfied by the prompts that are inputted into the AI tool. But essentially around this first point, there is a risk in terms of the level of involvement, human involvement in the creation of the particular work, that it may not be eligible for copyright protection at all, because copyright or the subsistence of copyright is a factual question, and the act then governs who the author is. So it's not simply saying it's created and therefore it belongs to me. It is actually a factual and a legal question that needs to be determined. The second issue in the copyright space is around disclosure of confidential information. And I think that this is the one area that most businesses and organizations have really looked into more and more. So as we know, IP is not just registered forms of IP. Many businesses have unregistered forms of IP, which are quite valuable, such as know-how, trade secrets, confidential source code. And some of you may remember in 2023, there was actually an instance where a Samsung employee had accidentally leaked confidential source code of the business by inputting it into ChatGPT. So this is a real risk. And the risk obviously is that it becomes public knowledge. It can then be used to train other AI models, and then there's a loss of competitive advantage if you don't have the right restrictions in place in terms of what AI tools can actually be used by your business. And then the last copyright issue is just around, infringements. And this can be split into two aspects. The first issue of infringements is just around using copyright works to train AI models. And a lot of the litigation outside of Africa has been centered around this very question, namely whether you can use copyright materials to train AI tools, and if so, will that constitute infringement? Now, the leading case on this is the US case of Bartz versus Anthropic. And essentially, Anthropic had or has an AI tool called Claude, and the way that they were training their AI model was to feed it information from certain books or sources. And their sources were twofold. The first set of sources were from original printed books, which they then scanned and discarded. And then the second set of sources were digital sources, but they were unauthorized or pirated copies. What the court said in this instance was that the use of the original books to train the model was fair use. However, the use of the pirated materials was not considered to be fair use. And the reason for that was because the court said that the use of the original materials was transformative use, and effectively it was using an existing copyright work to create something completely new and different. So that was a very clear sort of judgment. However, in the South African context, this decision of bots versus Anthropic is not entirely useful for us in terms of this defense of using copyright works to train AI models. And that is because in South Africa, we don't follow a fair use principle, but rather we follow a fair dealing principle when we are dealing with copyright infringements. And what does that mean? It effectively means that whereas under fair use, the courts have a bit more discretion in terms of deciding whether something is an infringement or not, under the South African Copyright Act, we have a closed list of exceptions to copyright infringements. And it is only in those circumstances that instances of which would otherwise constitute copyright infringement can then be defendable. Now, if you read those exceptions as they currently stand, there is no provision for the use of copyright works to train AI models. So currently, as the position stands in South Africa, it would still be potentially an infringement if you used copyright works to train your AI models in South Africa. And then this is just an interesting figure where I had mentioned that the court had decided that the pirated materials were not transformative use. The parties had actually reached a settlement in the amount of $1.5 billion for that infringement. Apparently, it's not such a huge number because it works out to about $3,000 per book. But in the context of copyright claims and settlements, it is in fact quite a huge amount that we have seen. But it's sort of just an indication of where the courts are going to with this. And then again, the second leg of the infringement aspect is the output. So a lot of the cases are around, the input and how you train your existing training models, your AI model, sorry. This is about what the output is and what your AI model creates. So there's an ongoing a matter between Midjourney and Disney. And essentially, Disney is objecting to the use by Midjourney of certain copyrighted characters and materials in its video creation AI tool. And Disney's argument is that this simply cannot be considered transformative because it's a copy and paste of an existing copyright work. So if you look at what's on the screen, I think it's very obvious that it's quite close. But I think what this case is also showing us is that the courts will consider each matter on a case-by-case basis. And therefore, even though, there is a rule that you can, in the US, use certain copyright materials to train your models, be careful that your output might actually be infringing. This is just a snapshot of the ongoing cases that are happening just in the US. Most of them are centered around the use of training models using copyright materials. And then in South Africa, and Africa generally, we don't have such a wealth of case law that is ongoing, so there's limited precedent. But if you look at this slide, you will see that within the various African countries, there's a lot of inroads that are being made in terms of developing some forms of AI strategy or AI policy or AI legislation that is looking to regulate the use of AI. I think that we've all seen the benefits of AI, and I don't think that that's going to change. I think we're just going to move forward, and it's going to be used more and more. And I think it's quite positive to see that, we are looking to making some of these changes. In South Africa, in 2024, we had the National AI Policy Framework that was issued. The framework does indicate that there's a need to regulate AI. We don't, however, have clear guidelines on exactly how we're going to do that. And if you look at some of the notable features of these policies or strategies across these jurisdictions, a lot of them are focused on building capability, on data protection, on ethical and safe use of AI. And there isn't a large emphasis on intellectual property. And I think that what this means is that either it will be dealt with as part of, an IP Act or an IP policy. Alternatively, it will continue to be looked at through the lens of existing IP legislation, which means that our courts will have to interpret how AI is used in the context of existing legislation, or, as Bernard mentioned earlier, we might be looking towards amending some of the existing IP legislation in South Africa. So, for example, we have the Copyright Amendment Bill that's been in the making for a number of years. And that bill, for example, does suggest more of a fair use type approach as opposed to a fair dealing approach. So it's possible that we might see some developments to IP legislation as we go about to cater for obviously the transformations that are brought about through artificial intelligence. And I just thought that I should put up the slide just to look at AI from a startup's perspective. I read an article that basically said that around $803 million has been raised, in capital for AI startups. It's funding that's been provided. I know that this is just a drop in the ocean in comparison to what they are doing or spending rather outside of Africa in terms of AI infrastructure and development. But I think it is an indicative that there's a lot that is going on in Africa in terms of AI, both from a startup perspective, building as well as using AI tools. And I think that it becomes really relevant whether you're looking at this as a startup who is looking to really, scale and build your AI and then license it out, or if you are a large corporate and you are looking to leverage off your startups and the IP that they bring with them. And in most instances, what those startups are bringing is really at its very core the IP. They're not bringing big buildings and lots of people, but it's the skill, it's the know-how, it's the tech that they are bringing. And I think that it's very important, obviously, that we get the intellectual property component of AI right in these investments and these dealings that we are doing with AI, because one, obviously, you might not get your core IP assets protected if you don't, look into it very carefully. The second thing is around your investments. You want to make sure that your investments are safe and secure and that you are investing in something that has high value. And if you don't own the intellectual property or you can't properly commercialize it for various reasons, that does impact its value. And then naturally, if you don't get the licensing aspects, if you don't get the ownership aspects right, that impacts your licensing and your ability to commercialize. And it also exposes you to certain litigation risks, which come with, as you know, reputational and financial loss. So with all of this said, I think one can summarize it in the context of what we see is we have existing IP legal frameworks which are being challenged. We don't have, loads of precedents, legal precedents that we can rely on to give us guidance at this point. We see that there's still a lot of development, both in our legal frameworks as well as in government policy, insofar as AI is concerned. So it's a developing area. And I think while this is developing, and until we have sort of solid or concrete guidance, we need to have certain strategies or mitigation strategies that we can use to help our businesses and enable them to be able to use AI effectively and within the right legal frameworks. So I've categorized these into 4 categories. And I think the first important one is obviously documentation. And to the extent that it is possible, it's always advisable to, document creative processes, prompt history, track human involvement where that's possible, because all of these will speak to, the authorship and the ownership of the outputs, if this ever becomes something that, is questioned. The second aspect is contractual clarity, and I can't say this, more, I can't emphasize this more, because this is where, we're really going to find the gaps, and this is where we can close the gaps. Looking at things like the terms of use for the AI generative model that you are using. What do those terms of use say in terms of opting out? So options to opt out. What do they say in terms of using your data or your IP to retrain models? What are some of the warranties and indemnities that are being offered? And then again, from a contractual perspective, just looking at, please excuse me. I'm battling, I'm recovering from a cold. Thank you, everyone. Just looking at your influencer and marketing agreements, and then any third-party agreements that you have with third parties who are your developers that are using AI tools, your governance, AI policies. Do you have those in place? Do you have guidelines for your employees? And as Bernard mentioned, your IP protection, making sure you have the right NDAs in place and maintaining your secrecy. And thankfully, that brings us to the end of my discussion. I'm going to ask Bernard to touch on questions for us.
All right, thanks everyone. We will move on to the chat to locate some of the questions. Okay. Please continue to post them in here if you have any further questions. We've still got some time. So the first question, do I have it in the right order? Yeah, it looks like it. Is from Precious. Do patents apply to software solutions that you can ask a vendor to develop for you and you give them all the specifications? Okay, that's a bit of a mixed bag of different forms of intellectual property. Typically, this is when these contractual agreements are very important that Janine mentioned, because you might have an idea and you want to contract a third party to protect this idea and develop this mobile application or software system, and you want to file for a patent. Now, there have been various different decisions to decide, who provides the innovative injection into this process. But typically, if you have a very good agreement to specify that all of the IP that's going to be created by that software developer will be owned by Precious, then you can file for the patent. And sometimes if you need to have an assignment agreement, then that can be filed with the patent. But that is typically what a lot of my clients do. Not everyone is a software developer. Some people are idea people, and they really have brilliant ideas and they work with a third party. But if you don't have the proper agreements in place, and I've seen this play out several times, and the moment you think just because you've paid that party, you own all of the intellectual property without a proper agreement in place. That's not always the case. So that agreement needs to be very clear in terms of ownership. And if not, and if there is what I always see happen is that you've paid them their fee that has been agreed, and then a news article comes out that you've got VC funding for several million rand. And now you try and file the patent, and they say you don't have all of the documentation, and now they hold you ransom for your patent. So please always ensure that your agreements are properly drawn up in the beginning. And that's also when all parties work together well. So I don't know if you've got any other comments there, Janine, but I think agreements are very important. And a lot of agreements don't deal with IP sufficiently, and it results in problems later.
Yeah, no, absolutely, Bernard. And I think your answer also touches on the second question that Precious has asked around, whether there's any particular clauses that one needs to put in contract agreements for such projects. And I think that there's no better time than now to revisit your IP clauses, especially in terms of AI and the tools that are being used by developers, because there's obviously clauses that will relate to ownership, and you need to ask yourself, what is it that you want to be able to do with what is being developed? Do you want to be able to commercialize it? Do you want exclusivity into it? And that is where ownership in your clauses has become absolutely key. And I think that sometimes, we try to, fall back on joint ownership because it seems like it's a nice compromise, but joint ownership is actually quite onerous. And we always say stay away from that if you can. So ownership of existing IP, which we will call background IP, ownership of foreground IP, which is IP that's going to be newly developed. But I would say also scrutinize your warranties and your indemnities and your undertakings that your suppliers are giving to you in terms of the AI tools that they themselves are using and how they are outsourcing that, and whether they can give you back-to-back warranties and indemnities, in terms of what they are doing. So it really is important to protect yourself and your business in that regard. Bernard, I think the next question is for you. What is the process of registering a patent in South Africa, and how quick is it?
Perfect. Thanks once again for the question, Precious. So I think there's also a bit of a misconception of, I think people think a patent needs to take several months and it's very expensive. I have filed patents and prepared them within a few days. It also depends on the complexity, and obviously if it can't be helped that you need to disclose it to a third party for reasons of getting funding, or maybe there is just a strict deadline and something needs to be filed, there are things like you can file a provisional patent. That's the one option where you describe the invention quite broadly, and then 12 months later you need to narrow it down a bit. But if you want to file the patent, it's not going to change over the next 12 months. We typically file a complete, and then 12 months later, you have to decide if you want to file patents in other countries. But that's something typically, you first want to get your peg in the ground, because you are protected from that point onwards. We always like to describe it as you get onto the patent protection train. The moment you're on and the first application has been filed, you kind of have protection globally for a period of 12 months. And at least then the parties or your employees or whoever can start disclosing it the moment that the patent is filed. Mind you, only for everything that's in the patent application. If 4 or 5 months later, someone asks you in a meeting, or one of your research and development team members, they say, "Ooh, but have we thought about this?" And it's actually completely different from the filed patent. Just be careful to disclose that, because it might have to be another patent application. But yeah, it depends on urgency. It depends on the complexity of the technology, but it can be a few days. If it's very complicated, you don't want to rush a very complicated patent. So then it can be a few weeks. So I think that answers that question, Precious, but let me know if it's not clear. The next one is very interesting, Janine. Are you going to take that one from Karen?
No problem, Karen. Thank you. So the question is, what would your advice be where a marketing team runs campaigns where you upload your photo into an AI tool and then the image of your face replaces the celebrity, or your face is in a famous movie scene, and does the same rules apply globally? So I think, Karen, this is very similar to the Reface app, example that we discussed earlier. And I would say that, if there's a replacement of your face, but there are still components of a person's personality that are recognizable and identifiable, such as their voice, and other aspects of their image, that could still be a personality rights issue. Particularly if you put it in a famous movie scene, and that person is obviously associated with that movie scene, and they're known for it. I think that you may still run into personality rights issues, because then the argument could be that you are, using some of the characteristics of the person's likeness to commercialize your own business, and that might be unfair to them. So in terms of the rules applying globally, I wouldn't be able to give you an answer of whether it's global, but for every country that does recognize personality rights, whether through specific legislation, like in the US, they have certain legislation, or other countries that have common law or recognize the common law, or have constitutional rights, I would imagine in those countries that the similar principles would apply.
Cool. Janine, I'm seeing more questions coming in, so I'm just going to let everyone know, that our emails are at the bottom if we don't get into everything, because Janine and I can answer all day and we love it. But I know everyone has time commitments, so I'm going to move on to the next one. It's quite a quick one. Sometimes trademarks, copyright, and patent, they all get a bit conflated. And I think it's just because we need to have these kind of sessions like we have today and happily answer your questions. But copyright is something that comes into existence automatically. Janine said there's one form of copyright that can be registered in South Africa, and that's for films. But that is governed by the Copyright Act, and copyright is for literary materials, music recordings, things like that, and computer programs. But patents are for systems or underlying technologies, and it's a very separate application process. You actually need to lodge an application, and that document needs to be in a very specific format. So they are quite distinct. There might be overlap in terms of what you protect, but copyright comes into existence automatically, whereas with patents, if you disclose something, you can no longer patent. That's the one takeaway I hope was clear today, because sometimes people come to me when it's too late to patent. And it's more difficult to prove ownership of copyright in court than a patent, because you get a patent certificate. I think the next question, if you don't mind, I'll also answer, Janine. I understand the recording is going to be made available. We will probably communicate that to the attendees, but it is being recorded, so love to do that if all goes well. Okay. And this one over
and
to
then the
you
next
as well,
question is, what if I use an AI tool and train it with my own copyrighted or not material, then use the tool to generate new material? So my understanding is that you are using all of your own material. It's created by you. You haven't copied it from anywhere else. I don't see that that's a problem. But also just bear in mind that the very nature of AI as a tool is that it does trawl through other sources that are available to create something new. That is just the very nature of how AI works. So even though you might be inputting some of your own material, if you are using the tool, you need to be careful about, the extent of the use, and read the terms and conditions of the tool that you are using and what that means for your exposure in terms of the use of that tool.
Just one comment there
Then,
before we move on to
yeah,
the next one. Sorry, Janine. Yeah,
no problem.
Pierre, just to also say, if you are licensing the underlying LLM or tool or whatever the case might be, it's quite important to look at that agreement as well to see if it provides you with some protection if the tool generates content that might infringe materials. So contracts, always very important. Sorry, Janine. Next one.
Yes, no, thanks for that, Bernard. The next question, someone's just asked me to share details about the Samsung case study. I will share the newspaper article. I'm calling it a newspaper, it's a digital article on it for your purposes, so no problem.
Sorry, Janine, once again to interrupt. I feel like I'm being very rude. Sorry, but
no, it's okay.
I'm also
Please,
finding this, my day-to-day is protecting inventions, and clients send me, we like to call it invention disclosure forms, and it sets out the invention, and then I advise on whether it's patentable or not. And I can see my clients sending me ChatGPT generated materials. It's so dangerous to deposit your idea or your materials into these LLMs, and various courts have decided, as was the case for the Samsung matter, that you disclosing your invention to the LLM might be seen as a novelty destroying event, and your invention might no longer be patentable. So very important to make it very clear to your employees, if you've got proprietary information, what are you doing? These frameworks that Janine mentioned of when and how you use these materials and feed it to these models, it needs to be very clear, because sometimes a R&D project might be several million in months, and then someone accidentally discloses it, like happened in Samsung. Sorry, Janine. Next one.
No problem. Siyabonga has asked, how is the South African National AI Policy Framework assisting with taking steps towards AI regulation? I've gone through it and note that it's very skeletal in its guidance. Would it be prudent to look to various jurisdictions' cases to help guide us? So I agree with you, Siyabonga. It doesn't offer much guidance in terms of how we intend to regulate AI. It just highlights that there is a need to do so. So currently, the most comprehensive piece of legislation on AI is the EU AI Act. And it categorizes AI into different categories, which are like high risk, acceptable, low risk. And then depending on where it's categorized, there's certain do's and don'ts. And seemingly outside of Africa, a lot of the jurisdictions that are coming up with AI legislation or AI policies seem to be following a very similar approach. I know that a lot of organizations in their AI policies or in their IP policies internally are using, the EU Act as a benchmark to try and create strategies around how best to manage and regulate AI within their organizations until such time that, we have some official guidance in that regard. So if there's anything that you do want to look at, perhaps maybe look at the EU Act and see if that helps in terms of understanding.
Cool. The next one is for me, I think, Janine.
I'll take this one, Bernard. It's fine. So, what is the law in relation to revolutionary IP developed by employees during the course and scope of employment if the work has not been patented by either the employee or the company? Looking back at the Vodacom case. Okay. So I'll separate. I don't want to get into a discussion on the Vodacom case that's been ongoing for so long, but it was more Vodacom, although it dealt with ideas and concepts, it was really more around a contractual bridge, because there was an undertaking to pay for the concept or the idea if it materialized, and that is exactly what happened. So that is more, it does touch on IP, but it is more a contractual issue. In terms of employees developing IP in the course and scope of their employment, it becomes very tricky because it depends on what form of IP you are dealing with. The Copyright Act is very clear that IP that is developed in the course and scope of employment belongs to the employer. However, although we can read it into other pieces of IP legislation like patents and the common law, etc., there isn't an explicit provision under the Patents Act, and Bernard will touch. I think Bernard can jump in from a patents and designs perspective. So when we advise on these aspects, especially when we're looking at employment contracts, we find that there's always a general provision in employment contracts saying that the employer shall own the IP. There's no, unless it's a form of copyright, there's no deeming provision that automatically gives the employer rights to that intellectual property. And that's why we always advise that there must be very clear provisions in the employment contract stating that the employee assigns, cedes, and transfers all of the IP that is developed in the course and scope of employment to the employee. And then obviously there is some case law about course and scope of employment. It doesn't necessarily mean that it's between 9 and 5 sitting at your desk. If you are using your company's resources, or you are doing something that really relates to your day-to-day work, and you wouldn't have come up with it but for the work that you do, the court can still consider that to be in the course and scope of your employment. So it is a tricky one, and it does need to be fleshed out quite clearly in your employment contracts. Bernard, can you maybe weigh in from a patents and design perspective?
Yeah, while there are case laws dealing with a lot of the patent and the design aspects, I think always your first port of call is having those agreements in place that clearly specify who is going to own the IP developed during the course and scope of the employment. Then if there is a potential dispute down the line of who owns the IP in the filed patent application or design application, if it ever becomes contentious, our officers have been found to accept employment contracts when they're unwilling to sign agreements to assign the IP. So, it's always important to have those agreements in place first so that you can protect yourself from a potential dispute down the line. But yeah, that was a very interesting case because it seemed at the face of it like a patent and IP case, because there were several other inventors that came out and said, no, they actually developed the underlying concept. But like Janine said, it was more of a contractual case. But what was very important about that case is, at least now I understand a lot of boardrooms are asking, do we have our ducks in a row to avoid a dispute? And it's also, you don't want to be in the news. You want everything to be nice and fair, and everyone understands contractually where they are. So it is very important. But yeah, contracts, it's always a strong basis for any company.
Yeah.
I think the next two are just nice comments. Thank you, and a pleasure.
Thank you very much for the kind comments. And we will share the presentation. Nomonde has asked, what considerations should you make when doing due diligences on startups using open source AI in their products? This is a very important question. And I think that sometimes, very often, particularly the IP components are overlooked when it comes to due diligences in this space. You need to ask them to disclose what type of open source AI they use. And what we generally do is we will ask for the disclosure. We will then go into those particular terms of use, because even though something is open source, I think that everyone thinks that open source means free for use, no contract, no requirements, no liability, and it's good to go. But that's not the case. What we would normally do is we'd assess the scope of the the liability, and we would also then question compliance with those licenses, so the extent to which you have actually complied. And what we've actually seen a lot of lately is that where organizations actually want to take out warranties and indemnities insurance, the insurers are becoming more and more strict around IP. They're asking very pertinent questions about things like open source AI and how do you mitigate the risk of infringements when it comes to using open AI. So I would definitely say that you call for it, and you'd obviously have to work with your IT team as well, because I believe that there is a way that they can be able to establish exactly what sort of open source is identifiable in the systems, and then look at what the exposure is, and then obviously either try and close it out by ensuring that there is compliance, or then getting the appropriate warranties and indemnities from your startup in terms of what they are or aren't using. I hope due diligences are a whole monster on their own, and we could talk about them the whole day. But yeah, I hope that gives you some guidance. This is a question from Deline. Hello, Deline. Bernard, do you want to pick this up, or do you want me to?
Yeah, this is it's interesting, Deline, and nice to hear from you. So I understand that this is popping up more and more, and you saw the court case from Midjourney, and how these court cases are coming about by people creating these digital replicas. Other than the takedowns and the usual routes, I've noticed that a lot of the companies are now starting to allow you to contact them and disable the generation of materials that include certain personalities. And I've only seen this for Sora 2, which I believe is part of OpenAI's digital material generation engine. So I think that's going to become more and more common, where you can actually explicitly not allow them to generate those type of materials. And I would encourage you to maybe reach out to those entities to see if that can at least be disabled. That's the only thing I am aware of. We know this is going to change every few months, but that's one very direct, I hope it's a little pearl of some sort of solution. But yeah, other than that, it's the usual course.
Awesome. The next question is about joint ownership, both parties contributing to the IP that's developed. Joint ownership is a question of fact. It is if both parties have, in fact, contributed to the development, then it is possible to agree to joint ownership. I did mention earlier that joint ownership, it does sound like a good compromise, but joint ownership is very onerous because it does require the parties to literally be tied by the hip. You have to get consent unless you unless you agree otherwise, in terms of how you commercialize, license, sell, or do anything with your particular portion of the IP. And the thing is that IP is, it's a bundle of rights. So when you have joint IP, you own an undivided share in the IP. It's not divided and separate. So because of that, it's very, very intertwined. And you just need to understand that when you go into a joint ownership relationship, that it might be quite long term. And if that relationship goes sour, just make sure that your agreement caters adequately for if that relationship ends. And usually what the compromise would be is that you give the other party an option to purchase your share of the joint IP when they leave. But just make sure that loophole is closed, so that there aren't any disputes between the parties when the relationship does end. The question is, can personality rights be encompassed in company organization popular policy? I have seen companies do that. So yes, I don't see why you can't include it. And then Jaden has asked, when vendors insist on excluding AI related rights, are there recommended compromise clauses, example, limited internal use, so that are considered to be acceptable in practice? So, Jaden, when I'm reading your question, it seems like you're asking, it seems like your concern here is that you have vendors that don't necessarily want to give you ownership rights in stuff that's been developed from an AI perspective. And if you don't own it, so you've got to always go back to the principles of IP ownership and what that means for you. So if they are insisting that they don't want to transfer ownership, what that means is that it might limit your ability to be able to use it or commercialize it at a later stage. So you might then, for example, want an exclusive license for a limited period to try and get some exclusivity so that you gain competitive advantage over your competitors. Or if it's in reverse, and say, for example, because I see you say limited internal use, where it's a scenario where, for example, you are developing something and you don't necessarily want to give someone else full rights, that is certainly something that you can consider is using it within a restricted environment. So that is also something that is generally acceptable. I hope that answers your question. In terms of excluding AI related rights. But if not, please give me a bit more context. You can send me a direct message and maybe I can just elaborate a bit more on that point. Thank you, Janet, for your comments. Very kind. Siyabonga, I think we've got 3 minutes. I'm going to try and rush through the last few comments, but if not, we will answer them in the chat, or our contacts are on the screen. Please feel free to contact Bernard and I at any point. We're very happy to chat to you. Siyabonga has asked, how can we advise marketing teams that are generating realistic AI images that may unintentionally replicate another's identity? I think you need to tell them that obviously they need to come to their legal person. They need to look, because it's not just about creation. The creation obviously has implications, as we've discussed. They have implications for infringing third-party intellectual property rights as well as third-party personality rights. So I think it's always useful, depending on what it is that's being generated. Some things you can actually check. So if you're generating, say it's not a facial image, but your marketing team is generating a logo, for example, that they want to use in a marketing campaign, you can actually do a trademark search to check that it's not something that already belongs to a third party. So it really just depends on what it is that you are generating. But I would definitely say that you perhaps maybe one of the practical things to do would be to give your marketing team a few pointers on what to look out for, and when to come to the legal team, etc. Although I would always say come to the legal team. It's always my go-to answer. There's a question from Farzana. I saw a point on due diligence. How will AI evolve the space, and what do companies need to factor in to evolve their due diligence process? I think I touched on this question briefly. When we do due diligences in mergers and acquisitions, we have altered our due diligence questionnaires. We have altered the way that we look at documentation and information in those VD art, bearing in mind artificial intelligence and what it means in the context of AI. So we ask very specific questions around the use of AI. We ask very specific questions in relation to the use of, for example, open source materials. So I think that, generally you can elicit some of the information from your due diligence process by asking general intellectual property questions, but I think that you have to actually make them a lot more focused from an AI perspective. There is we've definitely seen some evolution in the space in terms of how we are asking for information in due diligence processes.
Cool.
Bernard, I think that we have run
Reached
out
the
of
end.
time. There's a few other questions, and I hope that we've managed to answer most of them, but to the extent that we haven't, we will answer them. And please, we encourage you to reach out to us if you have any questions. We hope that you found the session informative and that there's some information that you can take out of this. And if you have a look at the presentation after this and you do have some questions around it, please do let us know. Bernard, anything from your side?
Nah, thank you. It was a lot of fun. I really enjoy a lot of questions. We're not just saying that. We love talking everything IP. So please feel free to send them onwards. Thanks for all the nice messages and nice to see some familiar names, and have a great week.
Thank you. Cheers,
Cheers,
everyone.
everyone.
Bye.